Attorney Anderson.
Good morning. May it please the court. My name is Holly Anderson. With me is Attorney Robert Riccio, who handled this case for the insurer through hearing. We represent the appellant, Massachusetts Education Government Association Self-Insurers Group, short MEGA. We contend that since we did not place the opinion of our consulting expert, Dr. Shea, at issue, under the rules and statutes governing workers' compensation cases, the reviewing board erred in three respects. First, in ruling that the employee was entitled to a copy of Dr. Shea's report. Second, in ruling that the employee could use Dr. Shea's report to cross-examine Dr. Basta, the impartial physician appointed in this case under Section 11A of the Act. And third, in requiring production...
What public policy is served by the position that you take?
Public policies regarding litigants' choice of their own experts to consult in private to determine how they proceed with their cases.
Do you know of any other context in which a person isn't entitled to a report of a physical examination of him or her?
Not in this jurisdiction, but I did look around, and I know that at least in New Jersey they have dealt with this by statute.
Whose idea was it that he undergo this examination?
I believe it's provided for under Section 45 of the Act, and the insurer is entitled to take the examination.
Right. So, but it wasn't his idea that he go take it.
No, that's correct.
So why shouldn't he be entitled to the results of the report?
Because under Section 45, which is how the report came into being, the only reason that the insurer has to provide it is if it intends to use it.
You don't think there's a qualitative difference between a physical examination of the other party and some other expert that as in under the rules of civil procedure, you have a non-testifying expert that you hire that does a report that you don't give over because you're not going to use it? I mean, it just seems to me, I don't understand a system in which there is a physical examination of somebody who isn't entitled to get a copy of that. What if it showed that he or she had some terrible disease and you don't give it over? Is that, it just seems crazy to me.
Well,
and also against various other statutes, but putting that aside.
Putting that aside, because we would submit that those don't apply where we're talking about specific workers' compensation context. The idea that there might be an undisclosed, unknown, different physical problem that, life-threatening or whatever, not to be flip, but that is a question for the legislature to deal with. And they have not here. They have in other jurisdictions. And I'm thinking in particular of New Jersey, where they've stated that by statute, and unfortunately I don't have the site in front of me, but I can provide it, where a physician examines someone on behalf of a third party, the report that it results is narrowly tailored to show the diagnoses that are relevant to the issues in question. The report is only produced to the third party that produces it, that requested it, and if the example that you bring up occurs, the physician has the duty under that statute to advise the employee or the examined party that they should seek appropriate medical treatment, but it does not require disclosure of the expert's opinions.
Now, why, you say the legislature has not spoken. The legislature enacted Section 20,
right,
which says all medical records and reports of physicians of the insurer shall be filed and open to the inspection of the division, and then it goes on to say such report shall be open to the inspection of any party. What's not clear about that?
Well, Section 20 is a general filing requirement, and Section 45 is a much more specific filing requirement. And it's our position that the specific one would control, where the two are not aren't necessarily. A report of an insurer is not necessary. The physician isn't necessarily the insurers in the sense that they don't have physicians on staff.
Okay, but the statute specifically speaks of physicians of the insurer.
But why would you need a filing requirement in two different places for the same report? Wouldn't 45 be more sensible in that case if the 45 report came in under 20? It was open to inspection under 20. Wouldn't 45 just have been a notice requirement is the question that comes to my mind. Why would you need a separate filing requirement and thus have 2 copies of the report filed with the division, the department?
Why is it not sensible to have one statute addresses inspection or discovery and another statute which says that if an insurer plans to rely upon it, you must make sure it is filed and therefore available to as part of the file of the case? Why is that not a reasonable legislative choice?
It would be, but I don't think that's what the legislature has done here. I think that they have set up 2 statutes, one of which is more specific and addresses the specific kind of report that we're dealing with here.
Now, do you also agree that if the insurer were to be unreasonable in failing to compensate, that it would be open to double damages for the failure properly to pay for somebody who plainly has been injured on the job?
I think that's, as a general proposition, yes, but
All right.
I don't think that you can use...
If the insurer has the individual go to their doctor with the IME, and the IME result says this individual was plainly injured on the job and is very seriously injured, and the insurer buries that report and fails to settle the case, how is anyone going to know that the insurer has acted irresponsibly, and how is the worker then to obtain double damages or other remedies?
I think that the employee, well, I haven't looked at this specifically, but to sustain such a claim, one could simply look at the medical testimony and evidence that was submitted, and if it's that clear, then I think that the employee could proceed on the basis of his own experts and his own treating physician records.
And you don't think it would matter in terms of evaluating whether or not the insurer acted appropriately if its own expert said that these injuries occurred on the job and are serious? That would not go into the calculus of whether or not you have acted inappropriately and should suffer double damages in the payment of attorney's fees?
I think it shouldn't, because there are a lot of reasons why the conclusions of an IME may not be perfect, and some of them have nothing to do with the issues that you're talking about.
Could I ask you about, Justice Gantz was asking about Section 20, and I
Sure.
happen to agree with his interpretation, but what about 30A also? Just explain to me, you read 30A, you say, any medical report pertaining to an injury which appears to be compensable shall be furnished by the physician or other medical provider to the employee, the insurer, and the department within 14 days. You say that what that requires is if the report says, I think this is compensable, it has to be given over. But if the report says, I don't think this is compensable, it doesn't need to be given over? Is that the way you read it?
The way I read it is appears to be compensable. It has to be measured from the point of view of the physician whose duty it is to produce it. And I would point out that Section 30A applies only to treating physicians under the regulations. I believe it's 1.13.
Under the regulations, it only applies to?
Yes.
Who does it apply to?
Attending physicians. Young versus Evans delivery, which is a workers' compensation case, also notes that treating physicians are subject to the provisions of that statute. But by its terms, it doesn't impose any obligation on the insurer. In fact, it imposes an obligation on a physician to produce to an insurer.
Yes, no, I understand, but the point is this employee is looking for that report. Mm-hmm. So whether it's from the doctor or from the insurer, I don't know it's going to matter to.
Well, it matters in the context of this case because all of this arose through a motion to compel IME that was directed to the insurer. And it was based solely on Sections 20 and 30A. And 30A doesn't provide a basis for a motion to compel against an insurer. That's how that came up.
Okay.
Now, with respect to your argument that Section 45 trumps Section 20 because it's more specific and more recent.
Yes.
What's left of Section 20? What value does Section 20 have?
Well, Section 20 is consistent with If there are, well, there are some employers that do have on-staff medical personnel. You know, you find that at self-insured hospitals a lot. You'll find it in some big manufacturers. They'll have occupational nurses. Those kinds of reports, I would think, would come be required to be filed under Section 20. The second issue that I raise in the brief is the ruling that the employee can use Dr. Shea's report to cross-examine Dr. Basta. Dr. Basta was appointed under Section 11A, and he has the ability to come to his own opinion based on the same kinds of facts and data that were available to the Section 45 examiner, Dr. Shea. The 11A physician performs the physical examination of the employee, looks at the medical records and treatment records that the parties choose to submit for review, and it's that ability to provide those documents to the impartial physician for review that makes 11A constitutional, facially constitutional.
But he didn't see this, right?
He didn't see this, but we aren't, under the rules that apply, we're not required to provide it to him. The only party that's required to provide anything in a conference packet, which is where they get put together, let me back up. Documents come to the 11A physician in the first place through what's called a conference packet. Each party puts together the medical evidence that it wishes to submit for consideration by the impartial. Once a conference order comes down and someone appeals to a hearing de novo, then those packets get transmitted to whoever is appointed to be, in effect, a medical master.
Is that the 11A?
That is the 11A physician.
Okay.
And the 11A physician's opinion, after he takes the performs the examination of the employee, looks at all of the medical evidence that both sides wish him to consider, informing his opinions, then he forms an opinion on his own. He can't defer to the opinions of anybody whose opinions are presented.
Okay. But then he can be cross-examined in a deposition, correct?
He can be cross-examined with whatever. Yes, he can be cross-examined in a deposition. That's correct.
So what's your argument about why the employee shouldn't be able to use the other IME in that cross-examination?
Because at that point, the rules of evidence and the rules that govern workers' compensation apply. And when there is something that can be admitted, it can only be, when a piece of medical evidence, a report, can be admitted, it can only be admitted by the party that procured the report under the regulations.
Well, could Dr. Shea have been deposed by the plaintiff?
No. Case law says, well, he could be if we put his opinion at issue, but we never did. We didn't refer to it. We didn't submit it as a basis for a decision by the department. We didn't refer to it in Dr. Basta's first deposition. We never put it into evidence or at issue.
So if, in fact, that Dr. Shea's examination had been provided, presumably, to the employee could have, maybe my timing is wrong here, but the employee could have included it in the packet of medical examinations that he wanted the 11A expert to review.
He could have tried, and we would have objected on the basis that we weren't placing that report at issue.
No, but this is a medical report of his physical examination, so presumably if we say he should have been able to get access to it, am I right, he could have placed it in the packet of materials he would want the 11A examiner to look at?
I think not, because where there is anything that can come in, where a piece of medical evidence is admissible, it's only admissible by the party that procured it.
But we're not talking admissibility. I just thought we were talking about the information that the parties have asked the 11A examiner to look at.
Right, but there's also a case called Fritz, and I reference in my brief, that talks about, again, it's the ability of the parties to introduce their own physician's evidence.
But they're not offering the report in evidence. They're only offering it to the independent medical examiner so that he can take a look at it and base an opinion on the total picture.
But the total picture, there are I can best explain it as I've written it in my brief, and I think I should rest there.
Okay.
Because unless the panel has any further questions.
Thank you.
Thank you.
Good morning. May it please the court, I am Attorney Edmund Hurley representing the employee, Richard Scott Higgins. In overview, I'd like to impress upon the court the modest relief that the reviewing board has given to Mr. Higgins here. Hasn't reversed any specific finding by the judge, the administrative judge, and hasn't put Mr. Higgins on benefits. All it said is that A, Mr. Higgins and his attorney gets a copy of the IME report, and IME does include the word independent, and that I can use it.
And a Section 45 examination is also referred to as an IME examination?
The Section 45, yes, Your Honor.
Okay, so.
Yes.
And do you also have a right to do your own examination of your own client?
Yes, Your Honor, we do. And typically, and in this case, it was all treating physicians.
Okay, so, and any examination, that medical examination that would have been done of your client at your request, either by the treating physician or otherwise, I take it would be discoverable to the insurer?
Yes, that's my understanding, that it would.
Could I have a clarification of the overall scheme regarding the IME, and maybe correct me if I'm wrong? I understood that the whole point of the structure of the IME was that there was one, so that you wouldn't have a lot of competing experts, cost savings for everybody. And so if somebody is permitted to go to another IME, essentially introduce that into the conference packet, don't you then have a situation that the structure was designed to preclude, which is essentially competing IMEs, and thus sub rosa, you can say, well, that IME says one thing, but this IME says another. Isn't that defeating the intent of the structure?
Well, it's not defeating, but it is, and Attorney Anderson referenced this and called Dr. Basta, the Section 11A doctor, I believe referred to him as a medical master. He does have prima facie weight. It is his, in this case, huge authority, which is almost plenary, that should give the employee, Mr. Higgins, the right. We know he has the right to cross-examine him, but for fruitful cross-examination. And it is therefore to say to Dr. Basta, well, here is another doctor. His weight is not nearly the impartial weight versus either a treating physician or an IME is apples and oranges. But did you think of this issue? Did you check his upper back? Did you look at arthritis or whatever medical issue it is? So it gives the employee the due process right to make his conceded right of cross-examination effective.
Well, you just said that it's apples and oranges to compare an IME to a treating physician, and isn't that what the structure exactly proposes? You've got treating physicians who stand in a different, long-term, looking for different things than outcome in a workers' comp case. And so if the insured goes to an IME just to say, look, I really need to know, is this a good case or not, which is very different from a treating physician, then why shouldn't they be entitled to internally take that look and say, okay, we'll go forward with the IME that's been appointed to be the IME?
Right, and technically it is the impartial physician. I think if the answer goes to public policy, if the effort is to obtain the truth of the matter, that is the employee's disability, the nature and extent and causal relationship to work, then exposing the impartial physician to both treating and IME reports enhances that ability.
I'm really confused with the terminology here. I can see under 11A, person is called the impartial medical examiner. You call the Section 45 doctor examination also an IME? It doesn't say that in the statute. That's just the insurer at any time can request that he be examined by a doctor paid for by the insurer. That's not an IME.
It is commonly referred to, it may perhaps inaccurately, but it is referred to as an IME.
But wait, but I was confused also. The IME is the creature of statute who's supposed to resolve this whole thing one way or another. I mean,
That's the impartial.
It's using
Right,
the term
impartial,
in
but
two
then-
ways.
But then what is this other doctor who performed the examination but for the insurer?
Here, Dr. Shea is the Section 45 IME independent medical examiner that is insured, rather that is paid for by the employer.
Can this be resolved by saying that there is an IME under Section 45 and an impartial physician under Section 11A?
There's no dispute that that is the case.
So
And how is it impartial if it's by one party?
No,
The impartial physician here is Dr. Basta. He was not paid by either party directly. He is the one that has the plenary authority, the prima facie authority. 11A is the medical master.
Isn't it fair to say that the IME, as we are using it, not Dr. Basta, but Dr. Shea, is in substance, I mean, he's the insurer's doctor. I mean,
Exactly.
He's not employed by the insurer, which is why he's independent. They pay him to do this exam, but he's basically the insurer's doctor.
Right. The analogy on an automobile tort liability case would be a PIP doctor. The insurance carrier might hire a doctor thinking that the chiropractic treatment's excessive, and it's called an IME. Plaintiff's lawyers might refer to it as an insurance medical exam. But the common parlance, even if it's not in the statute, is to refer to that, in this case, Dr. Shea, as an IME.
So it's really a misnomer.
Yes, Your Honor, it is. But I think it's important, in addition...
I take it that, all right, we'll call him the 11A impartial medical examiner, does get to receive information from the parties, medical information, that they think he should have the benefit of. Is that correct?
Yes, Your Honor.
And so I take it do you want this report so that you can include it in the packet for the impartial medical examiner?
Yes, Your Honor.
Is that what you want?
Yes, it is.
From a timing perspective, does that work?
Yes, it actually does. If I recall correctly, in this case, I believe the impartial report and the IME were not too far apart. But even if...
Well, you've never seen the impartial report?
Actually, Your Honor, I have.
Oh, okay.
Only at the end, I believe at the end of last year, based on the reviewing board's order decision, the administrative judge ordered and it was turned over, and it is favorable to Mr. Higgins.
Is this a Section 545 report that you've now seen?
Section 45, yes.
Does the when I was reading the briefs, I was under the impression that you wanted Dr. Shea's report so that you could cross-examine Dr. Basta. Is that a little incorrect in the sense that you really have to give the report to Dr. Basta first before, so that he can prepare perhaps a revised report under Section 11A, and then you can cross-examine him? Is that the way it works? Or could you cross-examine? Are you trying to cross-examine him blind, such that he has never seen Section 11, Dr. Shea's report?
The administrative rules are such that I am not supposed to give anything directly, but I would ask the administrative judge to forward to before the deposition so that he or Dr. Basta would have the opportunity to review it. And then he would go into in this case, it would be a resumed or a new deposition, and he can say this report doesn't mean anything, doesn't change anything.
Is that your plan?
Yes.
Is that required by the administrative scheme, by the regulatory scheme?
Well,
that you furnish him with the report before you can cross-examine him with it?
I have to confess ignorance. It's up to the administrative judge as to what goes forward to him, so that
But you can't. I think the question is, you couldn't you couldn't not give something to the administrative judge and then appear at the deposition and say, aha, look at this, Dr. Basta.
I don't think so. I'm not honestly sure, but if I did, it would be subject to objection and then possible striking later. But let's say I did find a treatise and I did bring it and read it and show it to him. I think it's ultimately up to the administrative judge whether any document, for example, Dr. Basta might have an updated curriculum vitae that perhaps the parties didn't have, and he might pull it out. That would be a non-controversial, updated item. But I think it is up to the judge.
Can I ask another clarifying question about the Dr. Basta? Are they part of a stable of pre-authorized IMEs?
Yes, they volunteer.
And they have to have certain qualifications, and then you select them from a list, right?
Right, and they are paid. Yes, they meet the criteria, and then they are somewhat randomly picked, but based in the area.
But from that roster.
Yes.
And Dr. Shea is on it too.
Oh, I don't know if Dr. Shea is on it. He may not.
That's my question.
I don't know if he's on it.
So the fact that he's called an IME has nothing to do with the fact that he is or is not on a roster of IMEs.
Correct. The impartial.
But is there a roster of IMEs, or is there a roster of impartial physicians?
As far as I know, just a roster of impartials. I believe that any doctor could hold him or herself out and say, I can examine you and write a report, not as a treating physician, but as an expert report. Some doctors don't practice medicine. They might just be IMEs for plaintiffs, defendants, or anybody.
If we agree with you that Higgins should have been able to use the report in cross-examination, what should we do then? Do you want us to recommit?
Yes, Your Honor.
Yes, okay.
And then it's my understanding the administrative judge would forward appropriate documents to Dr. Basta, perhaps have a status conference, and then we would redepose Dr. Basta.
Finish.
And then just have that transcript and then have another hearing, perhaps abbreviated, and then the administrative judge would make a decision as to whether any change is going to be made in the existing decision, which is a denial of benefits to Mr.
I
Higgins.
also have one other question about how this case actually got here. I mean, maybe I didn't understand it very much, but if this is
procedurally.
Is this the one, did you make an agreement in this case, an agreement for settlement, or am I confusing this with another case?
No, I filed a motion to compel that was never acted on.
Okay, all right, sorry. Okay.
Then we went to the appeals court initially, and then this court took it sua sponte.
Going forward, if we were to agree with you, I'm just trying to figure out how this works. If we were to agree with you so that under, let's just say under Section 20, this kind of report would be filed, and you would have an opportunity to see it. So then I take it you could include it in the conference packet that goes to the impartial medical examiner, correct?
I think procedurally I would speak to the attorneys on the other side. We would speak perhaps to the judge's clerk, and we might have a status conference as to what exactly would be included. But my understanding is, yes, we may or may not have a hearing at the administrative judge, but we would redepose Dr. Basta with that report.
No, I'm not talking about this case. I'm just talking about, I'm just trying to talk about procedurally. Let's say the rule were that an IME that the insurer does is available.
Right, it would be turned over immediately, and then the employee would, or his lawyer would have more, his or her lawyer would have more of an opportunity to get the report. And it doesn't happen that often because usually the report's favorable to the employer or insurance company.
I understand, but you got it available. So then you decide, I want it in the packet, or I don't care if it's in the packet or not. They probably would like it in the packet if it's favorable to them. But that's the place where, that's the moment. It's putting it into that conference packet that then makes it available to the impartial medical examiner before he or she has done the report.
Yes, and as I understand it, even before he or she has examined the
That's
employee.
what I mean. Yes, before, and then if you want to, you can raise it again in cross-examination of that medical examiner. But presumably the impartial medical examiner would have had it at the point that the doctor was doing the examination of the employee, right?
Yes, Your Honor. And I'd just like to note briefly, I know my time is running out, that even if this court would have believed that the statutes specific, Chapter 152, relative to workers' compensation, somehow didn't address the point, which I believe they do under Section 20. The other law that's been cited by both sides, and specifically Chapter 233, Section 79G, does say, in substance, that any record of an examination, if certified and if presented 10 days before the hearing, that is admissible as to the contents thereof. And we know that although this specific issue hasn't apparently appeared before,
Whoa. Are you saying now that you can admit into, after the impartial medical examiner has received all the information that the commissioner says he can receive and forms his opinion, you now have a hearing? You want to submit new reports?
No, not at all. It's not the case that we would change the procedural, but I'm saying that it is hearsay that a live witness wouldn't be there, that it could be certified, and yes, only if the administrative judge presented it. But the language of 233, Section 79G, does say that hearsay is admissible.
Does that statute apply only to proceedings in a court?
No, it refers to any agency.
It does.
Yes,
Okay.
and it's been amended, and there are lots of cases where, workers' comp cases, which have said that 233-79G applies. Now, not specific to this case with the Rule 45 report that the other side wants to bring in, but just in general saying that these are not, that this is an exception to the hearsay rule or is not hearsay.
Okay, but you're not suggesting that we should be ruling that you may admit the IME report into evidence, are you, under 79G? Or are you just saying that you want it to use for cross, or are you now saying you want to use it, you want to essentially claim that that statute is in conflict with the regulation which says that you can't offer that report as your own exhibit?
Well, Mr. Higgins is asking for both a copy of the report and does want it to be an exhibit so that the administrative judge can see it.
But that means then that there's a reg which says you can't use it. I mean, isn't there a workers' comp regulation which says that you may not admit a medical report that was not prepared by your doctor?
I'm not familiar with that.
Yeah,
452 CMR Section 1.11,
Oh, right.
Section 6. Party may only put in evidence medical reports prepared by a physician engaged by said party. Are you saying that this, I mean, you didn't brief it, but are you now saying in your last 30 seconds that you think that this is in conflict with Section 79G and therefore is ultra-virus?
Yes, I believe that Massachusetts General Laws, Chapter 152, Section 20 should take priority and that over that regulation. And Section 20 does refer to physicians of the insurer. So I would, in order to have to permit the administrative judge to see it,
I thought you wanted the impartial medical examiner to see it. You want the judge to see it too?
Yes.
Oh, well, that's different.
Is that
I want
something
both.
on which we would need a 16L letter?
I don't think in your brief did you say that regardless of this regulation, you should be able to put in evidence medical reports prepared by a physician engaged by the other party?
No, Your Honor, but I'm asking that it makes sense that if the administrative judge gets to decide what the impartial physician sees, that judge should be able to himself see it, and if an argument needs to be made, that it be an exhibit.
Well, when you say the administrative judge to see it, I thought that you were originally saying that the administrative judge acts as sort of a gatekeeper as to what the impartial physician gets to base his opinion on or her opinion on, and that you would then be able to use it to cross-examine. That it may not necessarily be admitted in evidence as an exhibit, but there are uses to which it could be put legitimately. That was the impression I got from reading your brief.
Well, obviously, that relief alone will be helpful to Mr. Higgins, and we do want to cross-examine Dr. Basta. but it would be up to the administrative judge as to whether or not it would be an actual exhibit.
But when you appealed to the reviewing board, did your appeal to the reviewing board include a prayer that that should be available in evidence, or did you only ask for what you got?
I believe I only asked that it be turned over and be used, turned over and that it be used for cross-examination.
Okay, so you're now asking us to do more than you asked the reviewing board to do.
I can't recall specifically asking, but if I'm going to show it to Dr. Basta, the impartial physician, then I would want it to be marked as an exhibit at his deposition.
Exhibit in
didn't
evidence
argue
or
that.
for identification? For ID or in evidence?
In evidence. Just like the treating medical records.
Okay, thank you.
Thank you.
Could I just make one comment to both sides? You know, these statutes, 20, 45, and 38, because it gets mentioned in the opinion, it would be helpful to have them in the briefs. Under our rules, you need to have them in the briefs, copies of.
Thank you.